Kaylee Wary versus Kendall Taylor.
For the record, this matter is before the court of the defendant's motion to modify parenting time and other relief. This hearing is being conducted via Zoom. Present is Attorney Anthony Brusco, representing the plaintiff mother, Kaylee Wary. Ms. Wary appears to be present with Mr. Brusco. In addition, Attorney Alexis Spencer is present, representing the defendant, the father, moving party, Kendall Taylor. And Mr. Taylor is present. Good morning, everyone.
Morning, Judge.
The parties have conferred this morning with Ms. LaPrade from the front of the court. The court's aware that we need a specific parenting time schedule. The judgment of divorce provided for parenting time as agreed. The recommendation of Ms. LaPrade is that fathers should have a parenting time with the minor children on Sundays from 10 a.m. to 1 p.m. The parties should meet at the dam in Dundee, weather permitting. The issue of child support shall be referred to the front of the court for formal investigation recommendation, with each side having 21 days in which to object to any recommendation. And the parties shall communicate regarding app close. Any child support ultimately ordered shall be effective June 1st, 2024. Finally, the parties will approve back for its court to review parenting time on August 6th, 2024 at 10:30 a.m. That is recommendation. Ms. Spencer, is this recommendation agreed with your client?
Yes, it is. Thank you.
Mr. Brusco.
Yes, Your Honor. I would add that Dad has agreed that he would be alone for his parenting time. I don't know if that was in the rec or not, but we did discuss it and Dad did agree to that.
Okay, it doesn't specifically say that, but I guess we can add that. So what if the weather is not permitting? I mean, obviously, the parties will meet there to exchange at there's a parking lot by the dam in Dundee, correct?
Correct. We did discuss if there were weather issues. They discussed possibly going to Cabela's, going to have lunch inside somewhere. They're going to be flexible and communicate with one another via app close. Okay,
that's the best situation. Of course, there's parking lots on both sides of the river and the dam, correct? So everyone, hopefully they can communicate to know where they're going to meet.
Yes.
If it's pouring rain, they're going to meet, then they can always talk and let's meet at Cabela's. But is it understood, Mrs. Spencer, that this parenting time will be unsupervised?
We call it quasi-supervised. So Ms. Wary will be in Dundee in the area, but she's obviously not going to be, standing over top of them.
She will remain, Your Honor. She's just going to allow them their space.
Okay, that's important. Yeah, obviously we don't, if mom's bringing the kids into Cabela's and she's going to be staying there shopping for a couple of hours, I mean, the kids are going to be turned around looking for their mother. So obviously there's got to be some space, without question, if it's going to be quality time between dad and his children. Right, it's clarified for the record. I don't think we need to change the recommendation as written, but everyone understands that mom's going to allow some space with dad and the children. Mr. Brusco, I'm sorry, you wanted to add something?
I was just indicating that this was the least restrictive way to accommodate a supervision, and it's like counsel said, this is a quasi supervision, but we want to accommodate dad, and we're not trying to have this set out into the future to do it in a therapeutic setting. So this was our compromise.
Okay, we lost Mr. Taylor. See if he'll appear back in. All right, Mr. Taylor's back in. Mr. Taylor, can you hear the court?
Hello?
Can you hear the court, Mr. Taylor?
Yes, it kicked me out for some reason.
All right, we just lost you a few minutes.
Okay.
Is it the intent that dad would have lunch with the children?
Yeah.
Yeah.
Right, meal?
Yes.
Okay. All right. So, Ms. Spencer, Mr. Brusco, either you want to bar your respective clients regarding this recommendation this morning?
No, thank you.
Kaylee, you've heard the recommendation that we just put on that Ms. LaPrade made.
Yeah.
Are you in agreement with that?
Yeah.
Do you think that this is a fair way to maybe step dad back into the children's lives in a safe and effective manner?
Yes.
Okay. Nothing further, Judge.
Very well. I think it goes without saying that obviously there can be, father can have such other parenting time as the parties can agree. It should not be limited to Sunday 10 a.m., but that's the minimum. So if there's something else that dad has going on, or a family gathering, a picnic, You should reach out to mom, and any request should not be unreasonably withheld, as long as mom knows where the children will be and how long and so forth.
Yes, and we did
Oh, the
discuss.
court will adopt the recommendation. I'm sorry, Ms. Spencer.
Sorry, I was just going to say that we did discuss putting, the kids' activities and things like that in app close in the calendar, so that if it's possible for Mr. Taylor to attend, he can do that as well.
Okay, give the other side sufficient notice, and this, of course, will start this Sunday, correct?
We are not entirely
Your
sure.
Honor, because we just selected Sunday as the day this morning, there are some pre-existing conflicts. We're working with those conflicts, and we're going to give Mr. Taylor as much notice as possible as to whether or not this Sunday will work. Father's Day is next weekend. He's been invited to the grandfather's Father's Day celebration picnic. If he's able to make that work with his schedule, he knows, and he'll be able to get the details from my client. Otherwise, it'll definitely be beginning the Sunday after that, if it doesn't happen until then.
Okay, is that agreeable, Ms. Spencer?
Yes.
Okay, we lost Mr. Taylor again. Maybe you can discuss that with him. Hopefully, when we come back in August, we can maybe perhaps adopt the front of the court holiday schedule. If father is exercising parenting time and developing a relationship with the children. All right, very well. The court will adopt the recommendation. The court finds it to be in the best interest of the minor children. And that will conclude this hearing. Everyone can zoom out. Have a good rest of the day.
Thank you, Your Honor.
Now in section middle of page 2, Devin Berry versus Autumn Club.
For the record, this matter is before the court for purpose of reviewing parenting time and any other outstanding issues. This hearing is being conducted via Zoom. Present as Attorney Leslie Carr, representing the plaintiff, Devin DeBerry. Mr. DeBerry is present, and in addition, Attorney Mark Gilbert is present, representing defendant mother Autumn McLeod. Ms. McLeod is present as well. Good morning, everyone.
Morning, Your Honor.
Morning, Judge.
The parties have conferred with Ms. Patrick, I believe, for the front of the court this morning. Ms. Patrick has provided the court with the following recommendation: that father shall plaintiff father shall continue to have parenting time on Tuesdays and Thursdays as previously ordered. Mother will do transportation at the beginning of the parenting time. Father will return the child at the end of the parenting time. The minor child shall be transported by a licensed driver in a car that is insured. And the parties will report back for its court to review apparently parenting time on November 12th, 2024 at 10 a.m. That is your recommendation. Ms. Carr, is this recommendation agreeable with your client this morning?
It is, thank you.
Gilbert, is this recommendation agreeable with your client this morning?
It is, Your Honor.
Well, would either counsel like to voir dire your respective clients regarding this recommendation, or is it not necessary?
It's not necessary on my end.
I don't believe it's necessary, Your Honor.
Very well. Court would like to thank Ms. Patrick for her assistance this morning, and acknowledge counsel for helping facilitate the resolution. The court would applaud mom and dad for reaching this agreement on continued parenting time. The reality is the two of you know what's best for your respective schedules and that of your child, so continue the good communication. And of course, parenting time is not limited to these times, but again, that's the bare minimum. If in fact there's something else coming up this summer, dad wanted to have parenting time, mother should look favorably upon their requests if it's reasonable. So with that, the court will adopt the recommendation. We'll see everyone back in November.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
You're welcome. We're going to zoom out. For the record, this matter is before the court for the purpose of reviewing the plaintiff father's parenting time and any other outstanding issues. This hearing is being conducted via Zoom. President Attorney Leslie Carr, representing the plaintiff Devin DeBerry. Is Ms. DeBerry present on audio? Ms.
No,
Carr?
he is not. He is not present, Your Honor.
Have you reached out to him? Maybe you forgot about the date and time?
No, he had left me a message yesterday afternoon while I was out of the office and indicated that he had gotten a new job and had work orientation that was scheduled at the same time as today's hearing. I contacted Mr. Gilbert this morning when I received the message, and we've discussed the matter and agreed to adjourn the matter for 90 days.
Very well, thank you. Also present this morning for the Zoom hearing is Attorney Mark Gilbert, representing the defendant mother, Autumn McLeod. Ms. McLeod is present. Good morning, Mr. Gilbert. Good
morning.
Recommendation from Ms. Brown for the front of the court this morning is that parenting time for the plaintiff father will continue as previously ordered, which if the court calls was Tuesdays and Thursdays. It's further recommended that the parties that appear back for his court to view dad's parenting time on Wednesday, January 8th at 9 a.m. Is that recommendation agreeable? Mrs. Carr?
Yes, Your Honor.
Gilbert?
Absolutely.
All right, court will adopt the recommendation. We'll put this on our docket, January 8th, 2025, 9 a.m. And now we'll conclude this matter. You can all zoom out. Have a good rest of the day. Thank you, Mr.
Thank you, Your
Your
Honor.
Honor.
Welcome. Is Dwayne Wilkerson present on audio?
Yes.
Good morning. Also present for the Zoom hearing is Monroe County Front Court Attorney Rebecca Hicks. Good morning, Ms. Hicks and Mr. Wilkerson.
Morning,
Mr.
Your Honor.
Wilkerson, you're brought before this court to presumably to commence contempt proceedings since you're not complying with court orders. Of course, going to have Ms. Hicks provide the court some information about your case. Ms. Hicks.
Certainly, Your Honor. In this matter, there is a current monthly support obligation of $641 per month. The total arrears balance is $26,221.91. Mr. Wilkerson has a finding of contempt from March 15th. It is a first finding and has a 45-day balance. That's March 15th of this year, Your Honor.
When was the last pay, Ms. Hicks?
He made a payment of $40 on May 31st, Your Honor. He made a payment of $20 on April 24th. He's making nominal payments. Your Honor, he did, when we were working on his contempt, he made a $1,000 payment in March to avoid any immediate jail, which is why he has 45 days hanging over his head. He did file a motion to modify his support, Your Honor. However, he failed to appear, and so the referee denied his motion.
Yeah, I didn't even realize. I thought it was all the same hearing as today. I didn't realize it, so didn't realize, didn't have my license. So, and my van just broke down. So, the best thing I can do is do the pickup work I've been doing. Luckily, I can jump on someone's truck every day, at least make something. Been trying.
Okay, but you've not, the $20 a month, $40 a month is not adequate, Mr. Wilkerson. You need to get back on track. You need to come down to the courthouse today, file a motion to reduce your support and show up for the hearing. You got to pay
Well,
attention.
when I did that, sir, when I
Mr.
did that,
Wilkerson,
like I said,
hold on. How do you support yourself right now?
I just told you I do the pickup work with the sewers. If we go
Okay,
out
come down
every
in front of the
day,
court.
I can make.
Before the court has a 4-page list of employers who are screwing for employees. Did you pick that up when you were last in
Okay.
court? Go
You
through
said
that
what?
list?
Yeah, I went through all the lists. I put down Indeed applications on the regular. Unfortunately, I thought I didn't have any license because the court said that they suspended my license. And then now, recently, my van broke down. So,
Well, if you start making payments and then and showed the court you're willing to address this matter, the court would consider reinstating your driver's license, Mr. Wilkerson, but you're digging the hole deeper. Every month it's adding $641 every month until you file a motion to reduce your support and show up for the hearing. There are a lot of good jobs out there.
I don't know what
you
else
got to
to
ride
say.
a bike, Mr. Wilkerson. The court is not content with your lack of cooperation. So I'm going to order that you appear later this week, Mr. Wilkerson, either bring $500 cash or bring a toothbrush. Ms. Hicks, when's a good day for you to appear with for Mr. Wilkerson to appear?
Either Thursday or Friday, Your Honor, would work, whichever
Mr.
works best.
Wilkerson, Mr. Wilkerson, the course.
I got my daughter's graduation on Friday.
Okay.
Morning and
During
Thursday,
Thursday,
so I have to be there.
That's fine. As long as you got the $500, you can be there on Friday. Mr. Wilkerson, you're
Can it
already
be
on
Friday
Thursday, June
after-
13th at 11:15 personally outside Judge Brown's courtroom. If you don't have the $500, you're going to serve a weekend in jail. So reach out to family and friends. Come down to the courthouse on Thursday, pay the $500, pick up a motion to reduce your support and pick up the jobs list, Mr. Wilkerson. It's real simple. You want to avoid going to jail this weekend? You want to go to that graduation? That's what you got to do on Thursday. It's Thursday.
Can I come down Friday afternoon?
I'm sorry, June 6th.
Can I come down Friday afternoon?
Any questions, Mr. Wilkerson? June 6th, that's
I was
this
wondering,
Thursday at 11:15.
I'm saying if I come down Friday, at least it'll all be one trip is what I'm saying. I have to go to Toledo. That way on the way back, I can just stop in the court.
All right, you want to come in Friday then?
Your Honor, I'm not available Friday afternoon.
What about Friday morning, Ms. Hicks at 11:15?
That's when he's saying his daughter's graduation is. He was
It's at
trying to
9
do it
o'clock.
after her graduation.
And then come back from Toledo or wherever it's at, back to Monroe that afternoon. I can't believe it's going to be no more than 10 or 11
All right.
o'clock.
All right, Mr. Wilkerson, you can appear then on Monday, June 10th.
Yeah. All right, June 10th, I have to be there. What time?
Monday, excuse me, Monday, June 10th, 11:15, appear personally outside Bronx courtroom. And what I'm hoping you can do, if you want to go home that
I'll
day,
just do it Thursday.
is to pay
I'll just do it Thursday.
$500. You get the job
just
list,
come
you file a
Thursday.
motion to reduce your support. Any questions, Mr. Wilkerson?
I'll just come Thursday because Monday is, I have a question, got to take someone to the cardiologist or whatever it is. I can just come Thursday.
All right, Thursday, that's June 6th, Thursday this week, June 6th, 11:15.
All right.
I'm on the 4th floor, hopefully they pay the $500. At that time, get the job list and refile your motion to reduce support. You're sitting on your hands, Mr. Wilkerson. You need to move forward. I'm trying to help you out here. Okay, this matter is adjourned June 6th, Thursday of this week, 11:15 a.m. See you then, Mr. Wilkerson. Yeah, you can zoom out. Okay. Mr. Wilkerson is present. He's out in the hall.
Court is now in session. Joanne Spain versus Dwayne Wilkerson.
For the record, Mr. Wilkerson, you are Dwayne Wilkerson, correct? All right, good morning. For the record, well, let's just change color. Mr. Wilkerson is personally present this morning for possible contempt proceedings. He has presented to the court a copy of a child support receipt that he paid $500 this morning. Also present, appearing via Zoom, is Monroe County front of the court attorney Rebecca Hicks. Good morning, Ms. Hicks and Mr. Wilkerson.
Morning.
Ms. Hicks, are you aware that Mr. Wilkerson did in fact make a $500 payment toward his child support arrearages?
Yes, Your Honor, that's reflected in our system.
Okay. Mr. Wilkerson, did you pick up a packet to file a motion to reduce your support?
Yes, I did put one in before, but I got the date confused what it was the other day. That was my fault.
You didn't appear and got dismissed, and you also got a copy of the jobs list, correct?
Yes.
Good. All right, so Mr. Wilkerson has done what the court has suggested. Mr. Wilkerson, you still have pretty significant outstanding arrearages. I mean, this is a arrearage where the Attorney General may very well pick up this case. Is that correct? And Ms. Hicks, in charge of Mr. Wilkerson with the felony of non-support?
Yes, Your Honor, his arrears balance is over $20,000 at this time. So this would be a case where the Attorney General could potentially review it and charge him with a felony.
Right. All right. Mr. Wilkerson, the Michigan Attorney General has been charging people in the state of Michigan with a felony criminal charge of felony non-support, punishable by prison. When the arrearages are this high, I'm just warning you, you need to really focus in and get this matter addressed. And I don't know if you have a relationship with Ms. Spain, the mother of your children, if she can waive some of those arrearages. I'm just saying you got to get this really quick, get this down because it's on their radar. And okay, I'm just telling you, if they do authorize that and you get arrested, the criminal court must set a bond amount of 25% of the arrearages, cash only. So we'll be looking at coming up with $5,000 minimum cash only to post bond. Other you spend all summer in jail. So really focus in on this, and yeah, be proactive. At least from this court's perspective, be proactive. File a motion to reduce your support. Show up for that hearing, and make payments in the meantime. Even if you got to mow grass, whatever you got to do to pick up, make regular payments. Right. In light of the fact that Mr. Wilkerson has done what the court suggested, Ms. Hicks, do you have an objection to continue this for another review?
No, Your Honor, I would propose that we adjourn this to July 30th at 8 a.m. back on my regular docket. to allow him the opportunity to get his motion scheduled. And even if the motion doesn't take place prior to then, hopefully he will at least have that in place.
All right. All right, Mr. Wilson, you've done what the court just suggested, and the court appreciates that. So we're going to take us off the court's docket, and you'll be mailed notice to appear before Ms. 6. You can appear via Zoom on July 30th at 8 a.m. And what you monitor that 8 a.m. July 30th, and the order that you'll receive will have Ms. 6's Zoom ID number. Gotcha. Or you can appear in person if you want that morning. She's going to look to see have you made payments between now and then. Gotcha. And have you filed your motion and appeared for that motion hearing date? The sooner you get that filed, the sooner you can get action. Let's say that you file it this week, but the hearing is not for another month. Any modification reduction goes retro to the date you filed your motion.
Last time they said they didn't get it, and then when they said they got it, I didn't realize they gave me a date. I thought it was the same thing.
Well, make sure that the front of the court has your valid address down there. And you're checking your mail because I'm mailing you notice. Is there anything further than this morning, Ms. 6?
Nothing further on this matter, Your Honor. Thank you.
Mr. Wilkerson, any questions?
No questions.
Okay, you're good to go. Have a good rest of the day. And
The court is now in session. Lady Rosenbart versus.
is Zachary White present on audio? There's Mr. White. Is Zachary White?
Yes, sir.
Okay, Mr. White,
Yes, sir.
you are brought before this court because it's presumably you're not complying with court orders, and the front of the court is asking they be held in contempt. This hearing is being conducted via Zoom. In addition to Zachary White being present, Merrill County front of the court attorney Rebecca Hicks is also present. Ms. Hicks, can you provide the court some information regarding Mr. White and his case?
Yes, Your Honor. In this matter, there's a current monthly support obligation of $522 per month. The current balance is $10,152.37. He does have a previous finding of contempt. It's from February 2nd of this year. It is a first finding, and there is a 45-day balance.
When was the last pay?
He paid $1,000 in February, Your Honor, which is why he has the 45-day balance in lieu of any additional immediate jail.
All right. All right, Mr. White, you've not made payments since February. And this is clicking along at $520 a month. Are you currently employed?
I am working for cash, not like full time, but I'm working. I'm making some money.
You're not paying this. All right, to Mr. White, the court's going to order you to personally appear on Thursday of this week. When's it good? Do you want to come in Thursday or Friday? And basically, got to bring in cash. Got to bring in cash and a toothbrush. Because otherwise, if you don't bring in cash, you're going to go to jail, Mr. White. I'm telling you that right now.
Yes, sir.
$1,000 cash. We'll have you come on Friday. Of course, you already appear before this court on personally. That's Friday, June 7th, 11:15 a.m. They'll give you a few days to get the cash together. Come up with bring in $1,000. And when you do that, file a motion, reduce your support, and pick up a copy of the jobs list, Mr. White. You're sitting on your hands. File a motion, reduce support if you don't have the income. So what I'm suggesting, if you want to avoid spending some time in jail, that you come be prepared, reach out to family and friends, get $1,000 cash together, pay that on Friday morning, get a copy of the job list, and at the same time, ask for a packet. You can file a motion, reduce your support.
Yes, sir.
Any questions?
No.
Okay, if you don't appear, the court will issue your bench warrant. That's Friday of this week, June 7th, 11:15, Bronx Court on the 4th floor.
Okay.
Anything further, Ms. Hicks?
Nothing further on this matter, Your Honor.
Okay, we'll see you on Friday, Mr. White. Reach out to family and friends. If you need to liquidate some assets, do that between now and Friday. And the $1,000 will be applied toward your arrearages. Can help you out.
Yes, sir. I do have a question
Go
that
ahead.
I was waiting for today for. I believe so. I'm not 100% fact, but I heard from my kid's mother that I have a warrant from the Attorney General, and I have the child support money. I just wasn't sure if I brought that in and paid the friend of court, if that would go towards my bond on that warrant.
Well, go toward your arrearages, yes. If you want to pay as much as you can pay, the better. I don't know about any warrants. That's the Attorney General's office.
If he were to, just so he is under, if he does have a warrant, if money that is meant to be bond on that warrant is different than child support payments through the friend of the court. That bond would eventually get released to the friend of the court, but they are handled separately. So that would be a
So-
discussion between you and the Attorney General's office. So the only way that you could handle that is by turning yourself into the county jail.
Okay, and if I was to turn myself into the county jail, would that $1,000 by Thursday be okay to take care of that warrant?
I can't
Do you
speak to
know?
that. That's the Attorney General's office and a different judge.
That's if it is, it's a criminal charge, Mr. White. It's not a civil family court action. But yes, obviously, if you can make a significant payment, that's certainly going to reflect favorably upon you.
Okay, okay, thank you, Judge.
All right, so we'll see you on Friday then, June 7th,
Yes.
15. I'd say pay as much as you can. That's going to reflect favorably. If the Attorney General is pursuing a criminal charge against you, pay as much as you can. That's going to help you in that criminal
Yes, sir.
case.
Yes, sir. Understand.
All right, see you on Friday.
All right, thank you.
Okay.
Court is now in session. Megan Busenbark versus Zachary Michael White.
For the record, this matter is before the court for possible contempt proceedings. Mr. White appeared before this court for an arraignment earlier this week. He was ordered to appear today. The court directed him to secure a job list as well as a packet of a motion to reduce his support, and also suggested he pay $1,000 toward the child support arrearages. This hearing this morning is being conducted via Zoom. Zachary White is personally present in court. Also appearing via Zoom is a Monroe County friend of the court attorney, Rebecca Hicks. Ms. Hicks, did Mr. White make any payment this morning?
Yes, Your Honor, I do see that a $1,000 payment was made today.
Wonderful. And it looks like plaintiff Megan Busenbark has also appeared this morning via Zoom. You are Zachary White, is that correct? Okay, Mr. White, did you get the job list?
Yes, I did.
4-page job list, and did you also pick up the packet to file a motion to reduce your support? Well, you've got lowered. You've got to fill it out and file it. The sooner you file it, the better. The court suggests file it today because you can't go retroactive, reduce it. The sooner you file it, even though the hearing date may be a month off, get it filed today because any reduction will go retro back to the date you filed it. So spend the next hour here filling that out and getting it filed. All right, in light of the fact that Mr. White did what the court requested, Ms. Hicks, do you have any objection to adjourning this matter?
I do not, Your Honor. He did have a previous finding of contempt, so we had put it over for sentencing today. If he could not come up with that $1,000, since he was able to make that payment, the friend of the court is not opposed to adjourning it back to my docket so we can monitor for continued payments moving forward and to see if he, files those motions and things.
Okay, and when do you suggest that?
Let me pull up.
Mr. White, make sure the front court has your valid mailing address too, confidential address, but make sure they've got it so that you receive notices. Because you'll be mailed a notice to appear for a Zoom hearing before Ms. Hicks, probably in about a month, to see if you're making regular payments between now and then.
Sorry, I'm pulling up the dockets. There we go. July 16th at 8 a.m.
So you must appear for Ms. Hicks, July 16th, 8 a.m. You can appear via Zoom. Copies are mailed to you. And she just wants to see if you made payments between now and then. Do you have any questions? All right, Ms. Hicks, anything further?
I don't have anything further, Your Honor. I do know, I think you already noted that the other party's on Zoom. I'm not sure if she had it.
Yes, Ms. Busenbark is present. Ms. Busenbark, this matter is adjourned to July 16th at 8 a.m.
In your child's behavior, and well, they might not.
Okay.
Yet, they're very
Well,
grateful to you. Over the course of the school year, your children have learned how to identify and write their names, throw, kick, and catch ball.
I'm sorry,
They
who's
learn
talking?
alphabet.
Who's talking? Okay.
It's my child's teacher. I'm at my son's graduation. I didn't
All
know
right,
about this
all
court
right.
hearing until last minute.
Okay, well, the next hearing is July 16th at 8 a.m. With Ms. Hicks.
Thank you, Thank you, Your Honor.
They have
All right,
learned
that will conclude this matter.
how to apologize.
Court is now in session. Leah Barnett versus Richard Lawrence Kausma.
Is Richard Cosima present? It appears that he is failed to appear. Ms. Hicks, you directed Mr. Cosma to appear before this court 11:15 today. Is that correct?
Did, Your Honor, and this is kind of an odd one. I'm not sure. I'm still kind of unsure how it ended up on my docket for today because there is an active bench warrant for him. However, I was hoping that he would Zoom in front of you and we could have addressed that issue. This matter had been one where he was supposed to appear in front of you on April 18th with $1,000 payment, and he did not appear or make that $1,000 payment, so you issued a bench warrant. So he already has an active bench warrant without him having appeared today. I just ask that that bench warrant remain in place until he turns himself in on it or gets picked up.
I do not recall that case. I do have some notes on my desk here that I'd like to have people picked up. That's Jason Pierce. He promised me he'd make a payment. I released him from jail. And also there was a Michael Tuminello. Those are on my list. I did not have Cosmo on my list, but anyway, yeah.
So that one makes that easy. It'll just stay.
Okay, bench warrant will remain in place. It looks like you had one bench warrant to be recalled. Is that
Gary
correct?
Collins versus Valerie Pritchard.
For the record, this matter is before the court on the plaintiff father's motion to modify custody and parenting time. This hearing is being conducted via Zoom. President is Attorney Anthony Breskel, representing the plaintiff father and moving party Gary Collins. Mr. Collins appears to be present with Mr. Breskel. In addition, looks like Attorney Peter Winter. Mr. Winter is appearing on behalf of William Amadio. Is that correct? On behalf of the defendant mother, Valerie Pritchard?
That's correct, Your Honor. Thank you, Your Honor.
All right. Good morning, everyone.
Morning,
The parties, and Ms. Pritchard is also present. The parties have conferred at length with Mr. Walker for the front of the court this morning. Mr. Walker has provided the court with a fine recommendation that neither party shall interfere with or allow a third party to interfere with the video chats between the parent and minor children. Mother shall take the minor child Penelope's special needs into consideration and follow any reasonable recommendation from Penelope's teachers and counselors that may interfere with her parenting time, as long as mother has had the opportunity to be a part of the discussions that led up to the teacher or counselor recommendations. When the parties meet for parenting time exchanges, father shall exit his vehicle and remove himself from the immediate area so that mother can come to his vehicle to get the minor children. The parties may enter an agreed upon order by stipulation that consolidates the various parenting time orders. Father shall have video chat with minor child Penelope every Tuesday and Thursday between 6 and 7 p.m. Eastern Standard Time during mother's parenting time. The party shall use AppClose shared calendar for all the children's appointments and activities. Any appointments or activities shall be added within 24 hours of notice or scheduling that are not an emergency. Neither party shall schedule anything for the minor children during the other party's parenting time. That is a recommendation. Mr. Breskel, is this recommendation be with your client this morning?
Gary, do you agree with this recommendation?
Yes, sir.
Yes, Your Honor.
Right. Mr. Winters, this recommendation agree with your client this morning?
I believe so. Ms. Pritchard, can you unmute yourself and say you agree with this?
Yes, I agree.
Thank you.
Wonderful. So right now, mother's parenting time, she lives in Arizona, correct?
That's correct, Your Honor. And
So her
she's here
parenting
in
time-
Michigan.
Okay. Her parenting time is during the summers as well as fall and spring breaks. Is that parenting time for the summers? Does that occur in Arizona or in Michigan?
In Arizona, Your Honor.
Okay. I don't recall the particulars. So everyone's on the same page in terms of when that summer parenting time takes place. Is it the second full week of summer after school is let out?
It's going to begin on Thursday this week, Judge, and we've communicated the details of the exchange in depth during our session with Mr. Walker.
Okay. And the minor children are still what, 16 and 10 years old, is that correct?
Yes, Your Honor.
And both children will be traveling together.
Yes, Your Honor.
Mom's here to receive them and take them back with her, Your Honor, yes.
I see. All right. All right, so Mr. Breskel or Mr. Winter, do either of you have wired their respective clients regarding this recommendation?
No, Your Honor, I'm satisfied with Mr. Collins' response to the agreement.
No, Your Honor, I'm satisfied as well.
All right. All right, the court would like to thank Mr. Walker for his time and assistance this morning, helping facilitate resolution, as well as, of course, attorneys Winter and Breskel for helping facilitate the agreement between the parties. And the court would applaud you, Mr. Collins and Ms. Richard, for each of your own agreement. You know what's best for your schedules and of your children. Children are going up fast. Before you know it, they're going to be on their own. So please work together and communicate for their best interests, particularly in the summer when they're significantly away from their friends here back in Michigan. All right, court finds any agreement between the parents being the best interest of minor children, the court will only adopt the agreement. Copy will be mailed out to council. All right, good luck. Now we'll conclude this hearing. You can all zoom out. Have a good rest of the day. The court, subsequent to the parties having engaged in mediation with Attorney William Godfrey, this hearing is being conducted via Zoom. President is Attorney Maria Zagorski, representing the plaintiff Mark Mansick. Mr. Mansick appears to be present with Ms. Zagorski. In addition, Attorney Kimberly Kuhn and Eric Chappell are present, representing the defendant Rebecca DeVoot. Is Eric Chappell, Mr. Chappell, you present in audio?
Eric, I actually had to go up to court, Your Honor. I believe he's with Judge Brown.
Okay, so Mr. Chappell did participate in the mediation this morning, but he is unavailable now. But the court was informed, Ms. Zagorski and Ms. Kuhn, that the parties have a temporary agreement that they wish to place on the record.
Yes, Judge, we've made some progress. We still have quite a ways to go. And just for keeping the file on track, the parties will be back before me on August 26th of 2024 at 9 a.m. That has been cleared by all attorneys, and we will reconvene at that time. There's a bunch of additional stuff that needs to be done between now and then, and I'll set that forth all in my letter between the parties as I always do. And then the areas that we have reached an agreement today, I could place on the record, Judge.
Please, Mr. Godfrey.
Thank you. We have two pending motions before Your Honor. One is a motion for school placement, and another is a motion for a play therapist. We've reached an agreement that the parties have dealing with both motions. The motion as to the play therapist has been agreed to as follows: that the mother will find a, quote, fully qualified play therapist, close quote, who mother can select, and that cost would be paid 50-50 by the parties as to anything out of pocket. This play therapist needs to be contacted in place by July 1 of 2024. That the information concerning this play therapist needs to be shared as soon as practical after it's been obtained. So once they select somebody that is a fully qualified play therapist, that information needs to be exchanged so Ms. Zagorski can review all of that. Anything dealing with the cost, appointments, and everything else needs to be then exchanged between the parties. They already are on the AppClose device, so that can all be put on AppClose immediately if the play therapist sets up any dates, times, appointments, whatever. That deals with the motion for play therapist. The second motion,
question.
Yes.
So Ms. DeVoot will select a therapist. Mr. Mansick will have to approve that therapist?
No, as long as it's a fully qualified play therapist, that is who it is.
Who determines the qualifications?
That is the state of Michigan. The state has a play therapist. I'm not sure if there's a certification or a licensing, but if they are a certified or qualified play therapist, so whether it's a license or a certification, they're it.
Okay, so mother will select a therapist by July 1st and inform Ms. Zagorski of the identity of that therapist. Is that correct?
That would be through the attorneys. Mother would select, advise Ms. Kuhn. Ms. Kuhn would advise Ms. Zagorski as to that. And assuming that that is a go, the appointments would be scheduled, and that can be close between the parties.
And the parties will share the cost of 50-50 equally, correct?
That's correct.
Thank you, Mr. Godfrey.
Out of pocket.
Okay.
The second motion was for school placement for year 2024-2025. That means the one starting. The minor child would continue in Michigan. That is the school the child has currently attended, and that would be for another year. Mother would pay for that cost. Third agreement is a father would have access to the Beulah, Michigan home to inventory whatever contents he may want to remove from that home. He can have access on June 14th starting at 9 a.m. through June 15th at 1 o'clock p.m. Father may go there, inventory the contents, and then exchange the list of items that he wants from that property with Ms. Kuhn to the other side by July 1st of 2024. Mother has already inventoried the contents which is occupied by husband, and that list should be exchanged as to the items mother wants from Cold Road by the same July 1st of 2024 date. The fourth agreement today is that there would be no physical discipline of minor child by either parent. And then fifth item, we're back here for mediation on August 26th. The parties know what to do with the tax returns, know what to do with other things that they've got to assemble before then. We've got Dr. Wooten, report is still not done, and we're going to push him to get that done by that date. And if there is still a vocational expert issue, that's got to be accomplished by that date as well. And other tax returns, yes. Thank you, Judge. He needs to talk to some collateral individuals, and that has not been fully accomplished yet. Dr. Wooten apparently had some personal issues that propped up, and he hasn't finished talking to the collateral individuals as best as I can figure.
Judge, to answer your question, because it's I who alleged that he hadn't been paid, and he hadn't been, but he has since informed us that he has been paid.
Thank you. With respect to Mr. Mansick inventorying personal property at Beulah, Michigan, Mr. Godfrey, Ms. DeVoot will not be present at the time he does that, correct?
That is correct. There is a manager. This is a rental home that is there. The manager, he can have access, and there's no rental during that period of time. So he's just going to inventory it. He's not going to remove anything. What he wants, he'll put on a list, and we'll exchange that. Very similar to what was done when Mrs. DeGroot went to the Cone Road property, and she inventoried stuff without removal.
Will the manager be present during that inventory process, or to make sure nothing's removed?
Okay, maybe. Housekeeper may have to be because there's either the housekeeper or the property manager. Rebecca will make arrangements with someone to be there.
Is that an issue or promise, Gorski?
No, I'm surprised that my client has to be babysat in property that he owns, but he doesn't object. That's fine.
I'm just raising it so we don't have an issue down the road that something's been allegedly removed from the home. All right, so Ms. Gorski, did Mr. Godfrey accurately state your client's interim agreement?
Yes, I hope it's understood that if Ms. DeVoot can find a therapist that's in network to keep the cost to the parties down, that she would do that. Is that, Kim, that's understood, right?
I think we're going to be looking at who's going to be the most qualified. So given that, obviously she'll look at that, but if there's somebody that's qualified that she chooses, she'll let Mr. Mansick know.
I did not find a lot of play therapists online, Judge.
I know it's tricky. So we will do our best, but find somebody who's qualified.
And hopefully she will start with what's in network and start there. Hopefully maybe she can find a qualified person in network. If not, then obviously the court will understand why she wanted network. But does that answer your question, Ms. Gorski?
Yeah, as long as she's going to try to, as long as she starts within network. I mean, if we can do that, she's paying for the coverage. I don't know why we wouldn't use it.
Okay.
I just don't know if it's recognized by the insurance as a legit coverage.
Okay. So we'll find out. Ms. Kuhn, did Mr. Godfrey state your client's partial agreement?
You did. Thank you.
All right. Do you want to voir dire? Both parties are present. They participate in these discussions. Do you wish to voir dire your respective clients regarding this partial agreement, Ms. Gorski or Ms. Kuhn?
I don't need. Thank you.
Okay. It might be helpful. Will someone prepare an order? Is it necessary to prepare an order incorporating Mr. Godfrey's recommendation? And obviously, it's on the record. Mr. Godfrey is going to apparently reduce something to writing. Ms. Gorski, do you believe we need an order? Ms. Kuhn?
I would think, Judge, as the order as to the two pending motions, at least that should go in there, and the order kicking it to mediation should go in there as well. I think.
And Ms. DeVoot filed the motion for school placement. Ms. Kuhn filed the motion for the play therapy. So do you want two separate orders, or council, you want to prepare one order with addressing both issues?
You know, Kim and I can coordinate. She can send me a draft, or I can send her a draft. We'll get something in her, Judge.
Right. The court would appreciate that order. And the court will also mail out notice about the continued review subsequent to the 9 a.m. August 26, 2024 continuing mediation with Mr. Godfrey.
Thank you.
Thank you, Judge.
Anything further than today?
That's it. Thanks, Judge.
Thank you.
All right. Thank you, Mr. Godfrey, for your time and efforts.
All right.
And we'll see everyone in August. All right. That will conclude this any time evaluation. Is that correct, Ms. Gorski?
Yes.
Is that correct, Ms. Kuhn and Mr. Chappell?
Yes.
Okay.
And with the court's permission, Judge, I'll place that agreement on the record.
Please, Mr. Godfrey.
Thank you, Judge. We have one minor child, Maggie, temporarily and pending further order of the court and without prejudice, the parties would share joint legal and joint physical custody of their daughter. Dr. Wooten has been trying to get a report to everybody for, I'm pushing probably eight months, and it has not come in yet. And the parties would stipulate and agree that Dr. Wooten's report would be sufficient for any party to seek a change in parenting time custody, and that neither party is prevented from bringing up matters or actions or acts that they think is important that predates this agreement. So if they want to go back 2 years, 3 years, they can bring up anything they want involving parenting time custody, obviously subject to what weight the court gives it. But Dr. Wooten's report we just don't have, and frankly, Judge, I'm tired of waiting for it, so we're going to go forward with what we've got. Is that sufficient, everybody, that for making a record on this, Ms. Kuhn?
Yeah, it constitutes proper cause or a change in circumstances. That's fine.
All right. Ms. Zagorski, do you think that we've covered it enough?
I do. Thank you.
All right.
So, Mr. Godfrey, in the interim, the parties will continue to share joint physical custody, correct?
That is correct, Judge.
Right, thank you.
All right. Parenting time by the parties is a 2-2-3 parenting time schedule, broken down as follows. Week 1, father would have Monday, Tuesday. Mother would have Wednesday, Thursday. Father would have Friday, Saturday, and Sunday. Week 2, mother would have Monday, Tuesday. Father, Wednesday, Thursday. Mother, Friday, Saturday, and Sunday. This schedule would continue. The parties would utilize the Monroe County Friend of the Court holiday schedule, absent a contrary agreement of the parties. For tax exemption purposes, the parties would share the minor child with mother claiming even years and father in odd. This would ultimately be a part of the child support provision of the judgment of divorce and therefore subject to modification by the court. Health insurance coverage for the child. Mother would continue to maintain health insurance coverage for the benefit of the minor child, so long as the same is available at a reasonable cost. Reasonable cost is defined as 6% of a party's gross income. When mother has the coverage, father need not obtain it. I was using, for purposes of the child support formula, a cost of $462 to cover the cost allocated for the child. Any uninsured medical expense would be split 80% by mother, 20% by father, after father pays the first $454 per year of uninsured medical expense. For purposes of the child support formula, it is $828 for the base support. Health insurance premium adjustment is $97, and then the ordinary medical care amount, I will figure that out, but it's going to be it so that we come up with the $753 total. And what I do, Judge, on this, I run it with 2 different methods. One with the mother claiming the child, and the following year with father claiming the child. That comes up with 2 different child support amounts. I add those up, divide by 2, and that's where the 753 comes. And I'll just fluctuate the ordinary medical amount to come up with the 753. One year it's 744 to father, and the other year it's 761 to father. So I just take that average and came up with the 753. Any questions by the parties so far?
No. Yes. The exemptions, that's tax year and not calendar year, correct?
That is, it would be even year, calendar year for the tax year that, so in 2024, mother would claim, even though the tax return is filed in April of 2025.
Okay, so it is not tax year, it's calendar year.
Calendar year. Well, it would be the 2020 taxes are filed in 2025.
Okay, and my other question was regarding vacation time.
Hopefully we will have that resolved, but before next summer, after Dr. Wooten's, I did not get into, unless the parties want to agree, 1 week each month during the summer.
A week.
Each month. I thought we already had something. Can we just continue on with what we have in place until we get Dr. Wooten's report?
Yeah, that's fine. That's fine.
2 weeks non-consecutive.
Yep.
Okay. Yep, that's fine.
Whatever notice, and then whatever notice there was, whatever we had. I mean, it sounds like we're operating off of that anyway, probably with the exchange time, with the way that they're
yeah, whatever they have been doing would continue.
Okay, so that the prior order, we're just gonna kind of take and put it into this, correct?
Into the judgment.
Perfect, okay.
All right.
Thank you.
As to extracurricular activities, if the parties agree to an extracurricular activity, that cost would be shared 50-50 by the parties. If they do not agree, then the parent that enrolled the child in that activity would be responsible for its cost. The child is in preschool, and that would continue. No decision has been made on school for 2025-2026 school year. So this is through preschool right now, so the child would stay in the young fives in 2024. The parties would be utilizing the app close device for communication concerning their child, and this should be used for all communications. The calendar for the child, or the calendar on the app close device, should also be utilized so that the parties can be kept abreast of any doctor's appointments or extracurricular activities, school activities, things of that nature. Child support, mother would be paying to father the sum of $753 per month commencing September 1st of that 2024, and as in the amount that I indicated. That would, a uniform child support order would enter. Anything else involving the child?
Yeah, with the extracurricular activities, if the parties don't agree, does the parent who doesn't agree, do they have to transport the child?
Unless it's a school-related activity.
Okay.
If it is not school-related, they do not have to take the child to that activity.
And Mr. Gaffer, I think we also agreed that the parties would enable, under the AppClose system, they would enable the ability to make calls on that program as well.
Yes, calls, video, whatever AppClose will allow. You can do video chat or snap, whatever they can do so that a parent can communicate with the child.
Okay. Thank you.
All right. In other words, we're not restricting any part of the AppClose. I mean, the calendar is going to be there, communication, audio, video, whatever they can utilize to keep abreast with the child. Then we go to real estate. There's one parcel that is clearly marital, and that's 1717. That property is only in wife's name, and the mortgage is only in wife's name. Wife would receive that property as her sole and separate property, and there will be a cash settlement that I will discuss infra judge, but mother will receive that. She will have to pay that cash by December 31st of 2024. If that is not paid by that date, the house would be sold. The net proceeds would be split 50-50. Any capital gains issues upon the sale or tax consequences from the sale would also be shared 50-50. I'm hoping we don't have to get there. Mother is pretty confident that she could come up with the cash, which I guess I'll say now is $310,000. And that cash would be paid by December 31st of 2024. If for any reason that does not occur and the house goes up for sale, it's the net proceeds that are going to be divided 50-50. But we're not going to parcel out what might be owed to wife's mother or what might be owed to father's mother, each of which puts some money into this house. And there's differing amounts, but it's just going to be split 50-50, whatever that may be, if it has to be sold. If the parties had any interest or husband had any interest in the property at 15159, that is kept by husband as his. As to this property, as to the one she was awarded, wife would hold husband harmless from any past, present, or future obligations concerning the property. On this property, there was rentals out for the summer. It's on Crystal Lake. Mother would be picking up all income on taxes that we'll talk about in a moment for this property on her return. If there's any sales tax issue, she's responsible for the sales taxes. As to the tax issue, the parties have had prepared a 2020, 2021, 2022, and 2023 tax returns, but they have not been filed. Each party would be filing for those years, married but separate. They can use whatever tax preparer they want to use. So if Leland Proshek, who is the current tax preparer, he should cooperate and give the file to whatever tax preparer each party wants to use, and each party is responsible for their own taxes for the property that they are being awarded. They pick their own income up, and they pay their own taxes or receive their own refund. Automobiles, wife is awarded her automobile, and husband, if he has any, is awarded his. Wife's currently is a 2020 Subaru. Each party shall be responsible for the taxes or expenses, plates, insurance on the items that they have been awarded, and they would hold the other party harmless from any liability thereon. If I did not say it, I should, that if there's any escrow balance on the Beulah property, that is awarded to wife. And I think there was some taxes paid as part of a mortgage payment, but that is awarded to wife.
Bill, does she also get, I think we also agreed that she gets all of the tax credits associated with the.
Anything involving that property, she keeps. The liabilities, the credits, the escrow, and has to hold husband harmless from any past, present, or future liabilities concerning that property.
That's what capital Gary said. Capital gains.
As to bank accounts or brokerage accounts, the parties would each keep their own. Specifically, wife had a TIAA brokerage account that was not retirement. She keeps that in a Vanguard brokerage account. Husband keeps his non-retirement accounts consisting of an American Funds, LPL Financial, and a Dearborn Federal Credit Union. There are some joint accounts. One is a Ameritrade, which as of today's date had $1,904. That is to be split 50-50. Hopefully somebody can create a new account at Ameritrade and just roll that over so that each keeps half. PNC checking and a premier money market were de minimis monies, but those are joint and would be divided 50-50. Somebody's got to go to the bank and just close those out and divide those sums. If either party had any other bank account that they may have in their name, they would keep that as their sole and separate property. As to retirement accounts, husband does not have any retirement. Wife does have retirement. Some of that was premarital, but for purposes of the settlement, all of wife's retirement accounts that she currently has are going to be treated as marital with a division date of December 31st of 2023. Wife would be entitled, or her husband would be entitled to any gain or loss from that division date on that account. Any cost by Ann Pastrana to prepare the quadros would be shared equally by the parties. If there's any cost by the plan administrator to implement the quadros, that cost would be shared equally as well. Specifically, the accounts that are being divided is wife's University of Michigan 403B value. Well, it doesn't matter. The 403B, University of Michigan 403B supplemental retirement account, and a University of Michigan 401A. All of these are at TIAA, Craft, being managed there. I assume there's going to have to be 3 quadros, but I'm not positive of that. But whatever is there as of December 31st of 2023, it's all marital, and it's going to be divided 50-50 as of that date. Personal property, the parties intend to try to resolve their personal properties on their own division. If there is any dispute, I would ask that the parties request an arbitration by September 15th of 2024. If they request an arbitration, absent a contrary agreement of the parties, I would act as the binding arbitrator. The sole role of the court would be to enforce the award of the arbitrator. Unless the parties demanded, the arbitration would be without attorneys, and they would share that cost equally. I have already exchanged some personal property list. Hopefully the parties can go through that and identify really what is in dispute, and they won't need me. But again, I will give them to September 15th. Do the parties think they can accomplish the exchange by September 15th, or do they want to go a little longer?
We're fine with September 15th.
We'd prefer September 30.
I don't have a problem with doing September 30. That's just to figure out what they want to keep or exchange.
Is that agreeable, Ms. Kuhn? Mr. Chappell?
Yeah, that's fine. That's fine, Judge.
September 30th? Okay.
Yes.
Life insurance, each party would keep whatever life insurance that they may have, free and clear of any claim, title, or interest of the other party. Husband has a number of business interests, all of which are awarded to him. I identified those as Mansik Trucking LLC, Mansik Farm, and AIS Enterprises LLC. Husband is awarded those, free and clear of any claim, title, or interest of wife. Husband shall be responsible for any past, present, or future obligations or liabilities concerning those businesses. On husband's tax returns, which he is filing married but separate, he would be picking up any gains, losses, or profit or expenses in relation to those businesses on his return. Wife picks up everything dealing with the Beulah property as well as her income on her return. And the parties would use that even odd for claiming of the daughter during that period of time too. Even years mother, odd years father. The only caveat with the picking up of the expenses in relation to properties is if the house has to be sold up north of in Beulah, husband and would be picking up any capital gains, if any, as part of that sale. Marital debts, husband shows up on 4 debts that wife is going to be responsible for payment of, and the 4 debts that shows up on husband's credit report are as follows: a Capital One account ending in 3703, a Capital One account ending in 7626, and a PNC credit card. I believe it's a Visa ending in 0703. Those 3 cards are still have an outstanding balance. That outstanding balance is approximately $23,444. Wife shall be responsible for payment of that. She can close the accounts, stop those. Husband cannot charge on those. He was an authorized user. There is one other account with PHD, that's Tom Henry Dog, CBNA, that is a Home Depot Citibank account, I believe, ending in 4105. That has a 0 balance, and that one can be closed out. They were not closed out before, Judge, because there was an order indicating that they shouldn't be doing closing out or affecting that. So we didn't have that taken care of based upon prior order of the court. But wife can get husband's name off of those 4 accounts, close them out, and eliminate husband's responsibility for any part of those debts. As to all other credit cards that are non-joint, each keep their own, and they shall hold the other party harmless from any liability. Wife would hold husband harmless from any liability on those 4 accounts that I just mentioned, the 2 Capital Ones, the Citibank, and the PNC card. Any other debts that I have missed?
The only thing that I can see is that there was a representation made that there are no loans against the retirement accounts, correct?
That is a correct statement. There had been a loan, but that had been paid off prior to the divorce being filed.
Yep. The last loan is being paid off in 4 days, Bill.
All right.
Yeah.
Okay.
Yeah.
On the retirements?
Yes.
Okay. The health insurance for the parties, each party is responsible for their own health insurance coverage post-divorce at their own expense. If either party had incurred any medical procedure that was not covered by insurance, each party shall be solely responsible for payment of their own uninsured medical expense. Wife would keep her devout last name. She never took husband's surname. Attorney fees, each party is responsible for payment of their own attorney fees and costs. Spousal support is forever barred, and the cash payment due husband by wife is at $310,000, and that would be by December 31st of 2024, and the court would retain jurisdiction over all provisions dealing with the terms of the judgment. Husband would release the cell phone number and phone through AT&T forthwith, so wife would keep her cell number and phone. That needs to be accomplished forthwith. On the property items, the one thing the parties have agreed to, if I can find that sheet, is as follows. Kayaks that are up north would be awarded to wife. The kayaks that are here in Monroe County are awarded to husband. The parties would copy all of the photographs involving Maggie, the minor child, and they would share that cost. That would be done through Walgreens in the Dundee, Michigan location. As part of the judgment, the parties would enter into a mutual restraining order that neither party shall stalk, harass, molest, wound, or any similar type language that would go into the judgment. And I think I've already talked about the at close used by the parties for all purposes. I think that's the agreement, Judge, but I got a ton of notes here. I think I've got it.
Mr. Godfrey, once again, with respect to the Cone Road property in Maybe, that's awarded to the plaintiff husband, is that correct?
That is correct, Judge. Yeah, I mean, wife thinks he's got interest in it. He says he doesn't. I'm just saying if he had any interest in it, I think it is only via a trust that will kick in if his mother passes away. So, for purposes of the divorce, I'm just saying to eliminate any concern about that, that's awarded. Whatever interest the parties may have had in that, he keeps. It might be 0.
Thank you. Thank you, Mr. Godfrey. Farrell, Mr. Gorski, did Mr. Godfrey accurately state your client's agreement?
Yes. Thank you, Judge.
Thank you. Ms. Kuhn or Mr. Chappell, did Mr. Godfrey accurately state your client's agreement?
Yeah, he did, Your Honor, but we did want to specify that with respect to the cell phone, and I know this seems like a small issue, but we've had some controversy with it, that what's required is that Mr. Mansick will either call to let them know that the transfer can occur and that it's her account, or provide a PIN to Ms. DeVoe so that she can effectuate the transfer. And we would ask, I know we said forthright, but we would ask that we could all agree, please, that be done in no less than 48 hours.
No controversy, Judge. In fact, we Googled how to do it today. He needs to get a PIN and he can do that in the next 48 hours.
Yes, yes.
Wonderful, thank you.
Okay, that was it, Your Honor.
All right, thank you. Mr. Mansick, Mr. DeVoe, can you both please raise your right hand? All right, Ms. Gorski, if you're going to begin with Mr. Mansick, please.
Yes, thank you. Would you please state, you can put your hand down. Would you please state your name for the record?
Mark Mansick.
And is it your testimony today that your marriage continues to be broken down and there's no likelihood that the marriage can be preserved?
I do.
And is it your testimony today that to the best of your knowledge, your wife is not pregnant?
Not that I know of.
Okay. And you heard the agreement that was stated by Mr. Godfrey?
I did.
You understand it?
I do.
You and I have been talking about this for, gosh, about 7 hours now, right?
Correct.
You understand all the terms and conditions?
I do.
And I know that you're not completely satisfied. Is that a fair statement?
True.
But you understand the math
I do.
and you're asking the court to adopt it.
Correct.
And you and I have talked a lot today about if we ask the judge to have a trial, that you could do better or worse, right?
Correct.
And you know those risks associated with going to trial and with agreeing to this today, correct?
Correct.
And with all of that having been discussed, you're asking the court to adopt this agreement?
That's correct.
Do you understand your obligations under this agreement?
I do.
You and I have talked about the tax consequences of this agreement, and is it fair to say that I have not given you any tax advice?
You have not.
And we've talked about the fact that I'm a lawyer, not an accountant, and that you needed to talk to your accountant, correct?
That's correct.
Okay. And you believe that, no, strike that. You understand that spousal support is forever barred.
Correct.
And you and I talked about the likelihood of you getting spousal support if we ask the judge to order it, right?
That's correct.
And that was contemplated when we came up with the final number that your soon-to-be ex-wife would pay you for your interest in the marital estate, right?
That's correct.
Do you have any questions?
I do not.
Have you disclosed all of your assets?
Yes.
Okay, thank you. That's all I have, Judge.
Thank you, Ms. Skorsky. Ms. Kuhn or Mr. Chappell, do either of you have any questions for Mr. Mancic?
Just a few, Your Honor. Thank you. Mr. Mancic, relative to the spousal support being barred, I want to make sure you understand that this is a final order and that what that means is that the court, your understanding is that the court is not retaining jurisdiction over that issue. So this is done essentially forever. You cannot come back at any time for any reasons and ask for spousal support in the future. Is that your understanding?
It is.
Okay. Can you also confirm that with respect to the temporary nature of the joint legal and joint physical components of custody, that you also stipulate and agree that what we placed on the record is a temporary order? Is that correct?
Is that correct?
Okay.
I think he doesn't know because that calls for a legal conclusion.
Yeah.
You stated it a different way.
Yeah, let me rephrase it. You understand we're all waiting for Dr. Wooten's report, correct?
I do understand that.
Okay, so if after Dr. Wooten's report comes out, we've agreed, and you agree with this, that essentially would be a change of circumstance, or I'll avoid the legal jargon. Based upon what Dr. Wooten report provides, you agree that each of you have the ability to come to the court and request changes.
I understand.
Okay, or an evidentiary hearing on that.
That's where the judge would take testimony and we call Dr. Wooten to testify about why he thinks whatever he thinks.
Right.
Okay, all right, thank you. That's all I had. You did.
Ms. Kuhn, do you have any questions of Mr. Mancic?
No.
All right. Questions for Mr. Boot, please.
All right, can you state your full name for the record, please?
Rebecca DeVoe.
Okay, I think we've taken the proofs already on this case, Your Honor, but I'll just reiterate some of the questions. You've concurred that there's been a breakdown relative to the marriage relationship. It's irreconcilable and you're asking for a divorce and continue in that regard.
Yes.
Okay, can you confirm that you're not pregnant? It's a necessary question for us. Okay.
Yes.
You like,
No.
you are not
Speak
pregnant.
up. Mr. Boot, you need to speak up. We're not capturing your, are you currently pregnant?
No.
Okay.
Thank
Yeah,
you.
when you answer,
Voice
speak
up.
towards that so
Sorry.
they can hear that.
Sorry.
You likewise have participated in this mediation session for a long time today, correct?
Yes.
Do you understand all the terms of the agreement that have been placed on the record?
Yes.
Do you also understand that you do have the right to go to trial and call witnesses, put evidence on, etc., and the court could make a determination as to what should happen with the things that we've agreed to resolve today?
Yes.
But you're agreeing to, you're waiving those rights in light of this agreement.
Correct.
Okay. And have you fully disclosed all your assets?
Yes.
Are you likewise, is it likewise your understanding that with respect to spousal support being barred, that with spousal support, that is forever resolved? You cannot come back to court and ask for any modification of that in the future. The court is not going to retain jurisdiction of that for any future involvement.
Yes.
Okay. Do you have any questions that have not been answered as of this time?
No, I didn't.
Okay. Thank you.
Thank you, Mr. Chappell. Mr. Gorski, do you have any questions of Mr. Boot?
Just one. Was there a loan against your retirement as of December 31st, 2023?
No, I just did it for 2 months.
Okay, thank you. And then I did have a question, I guess, for council and Mr. Godfrey. We're agreeing that Maggie's play therapy is going to continue at this time, correct?
I did not say that, but that was my understanding.
Ms. Kuhn?
Yes.
Yes,
That's correct.
yes.
Yep.
Okay.
That shall continue with the current therapist. Is that what you're asking for?
It
Play
shall continue
therapist.
play therapy as previously ordered, yes.
Yeah.
Okay, then that's all I had, Judge.
Thank
And
you,
we
Ms.
did not get a
Gorski.
letter from her as well, Judge. And one of the things that I was concerned about, apparently the play therapist said she would forward a letter to you. And I'm assuming if she did forward the letter to you, Your Honor, you would forward it on to the attorneys. I'm not sure why she won't send it directly to the attorneys, but at least at this point, there isn't a letter out there.
That's correct. When my client talked to her about her recommendations and communicating those, she indicated that she would only communicate directly with the court. I explained that the court would then share it with counsel, but to the best of our knowledge, there's been no communication so far.
Very well. And yes, the court has not received anything. Perhaps a friend of the court has, but the court is not aware of any communication from the therapist. But if the court is aware of one, the court will certainly forward it to counsel.
Thank you.
And who will prepare the judgment? Will you prepare that judgment, Ms. Gorski?
I will.
Very well. The court would like to thank Mr. Godfrey for his fine efforts and assistance this afternoon, as well as, of course, Attorneys Zagorski, Kuhn, and Chappell. The court applauds you, Mr. Mancic and Ms. DeVoot, for reaching your own agreement. Without question, the best resolution is one which you both participate, as you have today. Hopefully, you can continue that progress with respect to all issues involving your daughter, Maggie. You want your daughter to thrive, and she will if you're on the same page. As she gets older, she's going to sense when there's animosity and tension. So you need to always, in her eyes, respect the other parent. It's the little things that are important. Like dad always make sure you get her a card from mom for Mother's Day, and mom get her a card, or your daughter a card for dad for Father's Day. Those little things mean a lot to children. In that regard, the court did receive a certification that Mr. DeVoot completed the problem solving workshop, or the high conflict solutions workshop. The court received nothing from Mr. Mancic. Ms. Gorski, has he completed that program and written a statement?
He has completed the program. Did you write a statement?
I did. I'll forward it to you.
He'll forward it to me. I'll send it to the front of the court, Judge.
Thank you. I mean, forward to the court. The court's got the one from Mr. Wood. I'll make sure the front of the court has all of these.
Okay.
But hopefully the parties benefit from that program. That's all the court asks, is that two of you communicate effectively for Maggie's best interest. She's 4. It'll go quick, but you got a number of years you need to work together for her best interest. And I'm sure you both want her to succeed in life and have a healthy relationship with the other parent is critical. Based upon the testimony that's been presented today, as well as previously in the complaint filed this case, again, the court finds that jurisdiction has been established and that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed, and there appears to be no reasonable likelihood that the marriage can be preserved. Clearly, upon receipt of the judgment, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved, and judgment shall enter granting a divorce from bonds of matrimony. Thank you again, Mr. Godfrey. Good luck to Mr. Mancic and Ms. DeVoot. And that will conclude the proceedings for today, and hopefully, when you receive Dr. Moon's report, you can come to your own terms, an agreement with respect to your future raising of your daughter. So with that, everyone can zoom out and have a good rest of the afternoon.
Thank you.
Your Honor.
Thank you, Judge.
Thank you, Judge.
Thank you.
Mr. Boyer, can you remove your hat? We're going to begin now. Thank you.
The court will, the court's back in session, and we'll call the case of Venice Leon versus James Boyer. This matter is before the court on the plaintiff's motion to modify custody and other relief, as well as defendant's motion to modify custody and parenting time. This hearing is being conducted via Zoom. President is Attorney Catherine Kajewski, representing the plaintiff's mother, Venice Leon. Ms. Leon is present. In addition, Attorney Stephen Jednick is present, representing the defendant father, James Boyer. Mr. Boyer is present. Good afternoon, everyone.
Good afternoon.
Good afternoon.
Parties have conferred with Ms. Patrick, who has provided the court with fine recommendation that the issues of custody and parenting time be referred to the Minocqua front of the court for formal investigation and recommendation. There could be motions. In the interim, plaintiff mother will have parenting time Sunday until Sunday, the 3rd week of July, and the 2nd week of August in Grand Haven, Michigan. So they're not specific dates, but presumably the parties know what the what days we're beginning, and that'll be the third Sunday, presumably in July. Is that the thought, Ms. Patrick?
It is, Your Honor, the third week in July to the following Sunday, and then the second Sunday in August to the following Sunday.
So then July, that would be July 21st to the 28th. Is that correct? To make sure everyone's on the same page.
Yes, Your Honor.
And then August, mom would have parenting time the second week in August, from Sunday to Sunday. That would be August 11th through the 18th.
Correct, Your Honor.
Minor child will be interviewed by the front of the court as part of the custody and parenting time investigation. Neither parent shall discuss this case or a criminal case with the minor child. Minor child will reside in Grand Haven with the defendant father for the summer until the review date. That review date will be August 20th, 2024 at 1:30 p.m. Mother will be able to telephone. The child will be allowed to, directed to telephone her mother twice a week. Minor child shall engage in counseling. The minor child and stepbrother shall not be left unsupervised. That is a recommendation. Ms. Kajewski, is this recommendation agreeable with your client this afternoon?
It is, except for one provision for the summer parenting time. Mom lives in Monroe. We'd like to ask that she be able to exercise it at Monroe. She lives with the maternal grandparents. Additionally, while we're fine with those weeks, we'd also prefer if we could stack the 2 weeks together and just do 2 weeks at the beginning of July or the end of July. I think there's some transportation challenges and cost challenges. And if mom were to exercise it in Grand Haven, she would need to not only drive there, but and figure out a rental car to get there, but also stay in a hotel or motel for the whole week that she's there.
She has no other family in Grand Haven?
None. I don't think she does. I think that's why she moved back to Monroe.
And she has no automobile?
Currently, she does not.
Yeah.
All right, let's hear from Mr. Jednick. Mr. Jednick, does your client agree with this recommendation?
We're agreeable with the recommendation. As far as the proposal, I mean, our understanding was parent time would happen in Grand Haven. We don't care if the weeks get moved around, but while the minor child's and counseling and some of these other legal issues are being sorted out, we'd prefer the parent time occur in Grand Haven.
Presumably the counselor will be out of Grand Haven area, correct?
Yes, and the counselor is. The child is in counseling therapy, and that has already commenced, and that's in the area.
We did discuss that Mr. Boyer could check with the counselor if they offer remote counseling. Some of my cases are doing that now. The child could be brought to the library, to one of the client rooms, to the quiet rooms, to zoom in to the counseling from there, so that neither parent is influencing or involved in the counseling. If the therapist doesn't offer that, I suppose there could be a makeup session the following week, or some time tacked on the following week to that. I don't know a better way to get around that, but we're not talking about missing a month of counseling. We're talking about possibly missing one session.
Well, the issue is less about the counseling and therapy and thinking more about the concerns a minor child had with the grandparents' home. Miss Leon lives with her parents now, and there's a number of concerns discussed in mediation that we're worried about, let alone other issues about discussing the case. So that was more the motive of Grand Haven parenting time, for at least for the time being, than the counseling issue. I know counselors can be flexible. We're in post-COVID, but certainly we want those to happen under the circumstances. But the where parent time would take place is also an issue.
Okay, and the court doesn't want us to get into all those issues. Grand Haven is located on Lake Michigan, correct? They're close by?
Yes.
I mean, would they be, Ms. Kajewski, the court think there's got to be Airbnbs available rather than a hotel room that maybe mom can secure a place where the daughter could enjoy some time closer to the lake? I don't know. I'm just suggesting that. But we're talking about 2 weeks here. And if in fact this was fully discussed with Ms. Patrick, and Ms. Patrick is recommending, first of all, dad's opposed to the parenting time occurring here in Monroe in the grandmother's home, and the court's inclined to adopt this recommendation that the parenting time occur in Grand Haven. We're talking about 2 weeks. If in fact mom wants to make it a partial week, then all she got to do is advise dad, and it can be just a partial week if she can't find a place to stay a whole week, whole 7 days over in Grand Haven. What is the status of the criminal case, Ms. Kajewski? What's the window? Is that scheduled for a pretrial or a trial?
Yes, there's a final pretrial on June 27th. And there is not a trial date as far as we know. I think they're exchanging plea offers right now.
June 27th?
Yes. So we should know the resolution of that by the time we get to the custody investigation, I would think.
Right. Right. Anything further, Ms. Kajewski? The court understands your client's position. Obviously, she played a certain role in why she's back here in Monroe. Very unfortunate, very tragic, without question, especially with the minor child being present. But the court's going to rely upon Ms. Patrick when she recommends that the parenting time occur in Grand Haven. So mom will have to make it work. And if it wasn't work, she's got to inform dad she's not going to exercise her parenting time. She can still talk with her daughter twice a week on the phone. Have the parties, can they communicate in terms of what days of the week, what times, presumably in the evenings? Do we need specified times, or do you think the parties can work through that, Ms. Kajewski and Mr. Jednick?
I'm not opposed to specified times for the phone calls, at least in the short order taking place. Frankly, that might be one less issue for the parties to have a conflict about.
Okay. We can add this to the recommendation. What do you want to talk to Ms. Patrick again in terms of discussing what days of the week that the daughter will make a phone call to mom? I don't know if she's got her own phone. She's 12 years old. I don't know if she has relied upon her dad to facilitate those phone calls, but I'm going to put you back in the breakout room and talk to Ms. Patrick about that issue so we don't have any issues between now and coming back in August.
Sure.
That's fine. Thank you.
Thank you, Honor.
Court will recall the case of Venice Leon versus James Boyer. The parties have returned with their counsel discussing the days of the week that phone calls will be made from the minor child to mother. Ms. Kajewski, have the parties been able to reach agreement in that regard?
Yes, we've established for phone visitation. It will be Mondays and Wednesdays at 7 p.m. for a half hour. And we've changed the weeks for July and August to be starting the first Sunday of each month. So we stated the specific dates. Let me get them for you. July 7th. Yeah, July 7th through 14th and August 4th through 11th. And that would work better for both parties and the minor child's cheer schedule and visitation with out-of-town relatives.
Thank you. And the court does see the revised recommendation of Ms. Patrick. Again, mother will have parenting time Sunday to Sunday on the first week of July, as well as the first week of August. So it begins July 7th and August 4th. Again, the phone calls to mother will be Mondays and Wednesdays at 7 p.m. And again, they may not last a half hour. They just still have to see. Obviously, sometimes children don't want to spend that long on the phone. We'll just play that by ear. And hopefully it's productive. And we'll review everything on August 20th at 2024 at 1:30 p.m. Anything further than this afternoon, Ms. Kajewski?
Nothing further here. Mr.
Jednick?
No, that's acceptable to us, and we have nothing further.
Thank you, Ms. Patrick, for your assistance. Do you want to verify your respective clients regarding this recommendation this afternoon, Ms. Kajewski or Mr. Jednick? Is it necessary?
Very briefly, please.
All right, Mr. Boyer, Ms. Leon, will you both raise your right hand? Right, Mr. Jednick, you're going to begin with Mr. Boyer, please.
Yes, Mr. Boyer, you had a chance to participate in the mediation with front of the court today regarding the two motions before the court?
Yes. Yeah.
Okay. And there was a recommendation amounting that what will be a temporary order of the court, and you're supportive of that being adopted as a court order?
Yes.
Okay. And you understand that this doesn't completely resolve both motions. It's going to lead to further investigation. This will govern the parties for now, and we'll be coming back in August for further proceedings on these motions.
Yes, sir.
And you believe the agreement and the recommendation reached today is in the best interest of your child?
Yes, sir.
I have nothing further. Thank you.
Thank you, Jednick. Ms. Kajewski, do you have any questions, first of all, for Mr. Boyer?
Not for Mr. Blair, but for my client only briefly.
Please.
Sure. Ms. Leon, do you understand that today's resolution is an interim resolution and it could change pending the outcome of the front of the court investigation and the review hearing in August?
Yes.
Okay. And you believe it's in your daughter's best interest to have some parenting time with you in July and August in person?
Yes, ma'am.
Do you believe it's in her best interest to have phone contact with you on an ongoing basis?
Yes, ma'am.
Okay, great. Thank you, Ms. Leon.
Thank you. Mr. Jenick, do you have any questions for Ms. Leon?
No questions, thank you.
Very well, the court finds the recommendation being in the best interest of minor child at this point in time. Accordingly, the court will adopt the same. It will copy mailed out to council. We'll see everyone then on August 20th at 1:30 p.m. via Zoom once again. Right, that will conclude this hearing. Everyone can hang up, zoom out, have a good rest of the afternoon.
Thank you.
Thank you, Judge.
Welcome. Session will call the case of Ontropolis Crittenden versus Marcus Warren. For the record, this matter is before the court on the plaintiff mother's motion to modify transportation utilization of app close, as well as her petition for her to show cause. This hearing is being conducted via Zoom. Our President Attorney Kirsten Nemick, representing the plaintiff mother, Ms. Crittenden. Ms. Crittenden is present. In addition, defendant father Marcus Warren is present on audio. Good afternoon, everyone.
Good afternoon, Your Honor.
Good afternoon.
The parties have conferred with Mr. Pratt from the front of the court, who has provided the court the following recommendation that the person beginning parenting time shall be responsible for transportation. A person known to the child may assist with that transportation. Of course, we're assuming that person is a licensed driver and we have an insured motor vehicle. The party shall communicate via app close. Lastly, it's recommended that show cause be dismissed as Mr. Warren is currently unemployed, does not have insurance available. That is the recommendation. That was two things for the two bases for the show cause. The other one was that Mr. Warren is not paying child support since December of 2023. Is that still the case, Ms. Nemick?
It is, Your Honor. There was a hearing before Referee McKee on May 23rd, at which time Mr. Warren communicated that he had lost his job. It's my understanding that Mr. McKee adjourned the hearing until July 25th. While we were with Ms. LaPrade, Mr. Warren indicated that he's received a job offer from FedEx and that is simply waiting for completion of a background check, but that he had worked for FedEx previously, and he believed that the background check would be completed fairly quickly, and also that he intended to take a second job with Aldi. So I believe that by the July 25th hearing, he should be employed.
Absolutely. Mr. Warren, if that job does not turn out, the friend of course, a 4-page list of employers who are screaming for employees. I can get you a job today if you're motivated. Jack's Lawn Service, Michigan Bar. You just can't be choosy about a job. That's simply unexcusable. They've not paid any child support since December. It's a basis for contempt. So Mr. Warren, can come down to the front of the court. They have a 4-page list. You update it monthly. A lot of good paying jobs. So though you need to find something in case this opportunity with FedEx does not materialize. Understood?
Yes.
All right. Ms. Nimick, is your client agree with this recommendation this afternoon?
She is, Your Honor. Thank you.
Okay. So mother lives in Indiana and dad lives in Ohio. Is that correct?
That is correct.
What's the time of transportation back and forth?
Antonasia, can you answer that?
About one way, about 2 hours and 45 minutes.
Well, almost 3 hours. And this is occurring every other weekend. Is that correct?
Yes. The first and third weekend.
Yes. First.
Mr. Warren has parenting time from Friday until Sunday.
So a lot of that child's in the car for long periods of time. Mr. Warren, do you understand the recommendation? This recommendation is that when it's your parenting time, you're responsible for the transportation.
Yeah, I understand it, but I don't agree with it. And I cannot physically do it because I'm not working. I don't have the gas money to even drive anywhere. And I'm trying to get 2 jobs again. So I'm not even going to have time to drive once I get the 2 jobs. And I got to maintain 2 jobs to pay $500 a month in child support.
Ms. Nemick, this recommendation is that Mr. Warren will pick up and drop off. Is that correct? He'll drive both ways?
No, it was that he would provide half of the transportation. It was that the parent who was beginning their parenting time was responsible for transportation.
Okay. So when his dad's parenting time, he'll pick up and then mom will pick up from Ohio.
Correct. Although Ms. Crittenden would be amenable to considering splitting the transportation both ways and meeting halfway if Mr. Warren wanted to consider that.
I don't
That may-
have the
What about that, Mr. Warren? Finding a halfway point, meeting halfway.
I understand, Your Honor, but you have to understand that I didn't create this distance. I was against this distance from the beginning, and making me even reliable for half is kind of unfair to me because I don't even want him to live in Indiana right now as we speak. Our case is in Monroe, Michigan. None of us live in Michigan.
So you're opposed to this recommendation then?
Yes, I cannot do it. I can't drive all the way to Indiana. I'm not gonna feel like I'm gonna have the time, and I don't have the money right now while I got the time.
Well, why don't you meet halfway then?
Because I won't have the time, because normally when I work Sunday through Friday, so I can have the weekends off for Marcus, and I tell every job this. Normally, if I have to work 2 jobs, I have to go in the evening of Sunday, and I don't get off, and maybe not until midday on a Friday, to where sometimes my mom has to get Marcus for me until I can get to him because I'll be at work. And I'm trying to get 2 jobs again, and I need it, so I might not have the time at all, working 2 jobs.
Your Honor, if I may, as Mr. Warren just pointed out, he has family available to assist him. His mother can assist in transportation.
She will not do it. You can ask her. She's going to say no. She's going to say she got too much to do. And she
doesn't want to spend time with her.
family.
She doesn't want to spend time with her grandchild, Mr. Warren?
She will spend time with him, but she's not about to keep driving consistently to go pick no one up from halfway or anything. She told Antonasia no before when they had their own conversations. Now, that's outside of me. I can't tell what someone else is going to do. All I know is what I can do. And I can't provide transportation right now because I don't have the money. And even when I do get the money, I might not have the time. That's why I asked her not to leave Michigan, because of this.
Your Honor, if I may, and Antonasia, tell me if I'm misstating any of this, but it's my understanding that at the time that Ms. Crittenden moved to Indiana, the parties agreed that Mr. Warren was going, so let me step back. The party's minor child, Marcus, has special needs. When Ms. Crittenden moved to Indiana, she was able to set up services for him there that she had been unable to obtain while she was here in Michigan. It was the party's understanding and agreement that Mr. Warren was going to set up services for the minor child at a sister facility in Maumee, and that Marcus was going to come back to Mr. Warren and live with him and receive those services in Maumee, Ohio. Mr. Warren never set up those services. That was 4 years ago. That's all correct, right, Antonasia?
Yeah, fine.
Since that time, Ms. Crittenden has had sole custody of this child. Mr. Warren only sees him on those 2 weekends, the 1st and the 3rd. And in addition, he's not even paying child support. So she does everything for this child who has special needs, including managing all of the services. He's not providing insurance. And while that part of the show cause is being dismissed because he currently is not employed, at the time that we filed the motion, he was employed. He did have insurance available to him, and he chose not to offer that for his minor child. This is one of the rare instances where secondary insurance was actually helpful because of the child's special needs. In addition, he was employed and he still wasn't paying his child support. So all of this burden has fallen on Ms. Crittenden, and she's simply asking for him to assist in transportation. I think, given that he is not paying any child support and hasn't since December, it is now June, and because he expects to be employed here momentarily, according to what he said while we were before Ms. LaPrade, that he should be able to assist in this transportation easily.
Right. The court, thank you, Ms. Nimick. That does refresh the court's memory. I do recall back when Ms. Crittenden petitioned for permission to move to Indiana. Mr. Warren's going to set up services for the minor child here in Maumee. It never happened. So the child's been living with mom. Mr. Warren, obviously, you could have made those arrangements. You didn't do that. So at this point in time, the court's going to adopt this recommendation. If you can't drive, and your aunt, anyone that the child knows can help assist with transportation. And if you cannot drive, if you want to drive one way, then you work out and share the cost. So the intent of the court is that you share the cost, share this transportation, whether you drive halfway or you drive all the way to Indiana, and your mom, and then Ms. Crittenden drives all the way to Ohio. The party beginning parenting time shall be responsible for the transportation. But again, even though that's the way this is worded, Mr. Warren, if you want to drive halfway, you communicate with Ms. Crittenden, you can agree upon a halfway point. That probably makes the most sense. You could have avoided this if you would have set up those services for your son back 4 years ago. If in fact you get this new job and it interferes with parenting time, Mr. Warren, you can always petition the court to modify parenting time. For example, if you're working on Saturdays and you can't want to have time to see your child, then petition the court and we'll talk about some summer parenting time, days when you are off. If you can't work it out with Ms. Crittenden, you can petition the court and the court would try to accommodate your work schedule. But at this point in time, your parenting time will continue the first and third weekends of the month. And rather than mother provide all transportation, you shall share that. Anything further, Ms. Nemec?
I have nothing further. Thank you.
Mr. Warren, do you have any questions?
Yes, I got a lot to say because some things just got said that was not true.
No, Mr. Warren asked you, do you have any questions?
I have paid child support in the last month. I have.
Did you have any questions, Mr. Warren? That was the question. Do you have any questions? The court has made a decision.
Off of false information?
Okay, what information is false?
The information I didn't pay child support is false. The information that I refused to set up services for him, I got that agreement taken away from me. It was nothing I could do.
Well, the show cause is being withdrawn at this time because you're off work and hope to have a job. So no one's asking for contempt for failure to pay child support. But I think we look at friendly court records, it would show that you're not made payments since December 2023.
That's not true. That's not true.
Your Honor, there have been payments made. I would assume those are going to stop since Mr. Warren has been terminated. There were some payments in April and some in May. And Ms. Crittenden is welcome to contact the caseworker. But other than April and May, it was December, Your Honor.
All right. So, yeah, Mr. Warren, the court stands corrected. You have made some minor payments. But again, the show cause for not paying child support has been withdrawn. So that's not an issue. Child support is not an issue right now. It's simply transportation.
But Your Honor, the reason why she provides all transportation now, because you guys rule it then that she supplies all transportation for leaving to Indiana and get the court orders. You guys didn't give her permission to leave when she left. You're going to hold her in contempt if I didn't come up with that agreement.
Do you remember 4 years ago, you were going to set up services for your son in Maumee. Do you remember that?
But you took the agreement away from me. How can I do that if you take the agreement away from me?
He gave you an entire year to do it. It doesn't take
but
that
no
long
one
to
told
get
me
him
I
on
had a
waiting
year
list.
to get it done, and then I got.
It doesn't take that long.
And that derailed the prompt. Why are you talking anyway? Why can't I say what I got to say?
Right, hold on. This is not time for the two of you to argue. Mr. Warren, this matter was adjourned so that you could consult an attorney. You've had that opportunity. The court's made its decision. You returned without an attorney. The court's made its decision. So that will conclude this hearing. If your work schedule does not permit weekend parenting time, the petition the court will modify the parenting time so you can spend time with your child. But the transportation will be shared by the two of you back and forth.
I will not do that.
All right.
I will not provide transportation.
Your Honor, I just want to point out that Mr. Warren is indicating that he will not provide transportation. So my client is free. If Mr. Warren does not come and pick up his child, I just want to make it clear on the record, Antonasia, you are not violating any order. If he doesn't come and pick him up, then he doesn't get his
I'll wait to get a lawyer. I love my son, but I'll wait to get a lawyer.
All right. All right. That concludes the matter. A copy of this order will be mailed to Mr. Warren as well as to Attorney Nemec. Now concludes the hearing. You can all zoom out. Have a good rest of the afternoon.
Thank you, Your Honor.
Court is now in session. Top of page 4, Jacob Hugendorf versus Chelsea Takoviak.
For the record, this matter is before the court on the plaintiff's amended motion to modify parenting time and other relief, as well as defendant's motion to modify child support. This hearing is being conducted via Zoom. Present is Attorney Alexis Spencer representing the plaintiff, Father Jacob Hugendorn. Mr. Hugendorn is present with Ms. Spencer. In addition, Attorney James Adre is present representing defendant mother Chelsea Sidkoviak. Ms. Sidkoviak is also present with Mr. Adre. Good afternoon, everyone.
Good afternoon, Your Honor.
One moment, I will access and share Ms. Patrick's recommendation this afternoon. Is that father shall have parenting time every Wednesday after school until Friday back to school, and then every other weekend from Friday after school until Monday back to school, Monday morning. Parenting time will be the same schedule during the summer with exchanges at 4 p.m. on Wednesday until 4 p.m. on Monday. Parties will share transportation with the party receiving parenting time, so doing the pickup in the summer and holidays. Parties shall use the friendly court holiday schedule with the defendant mother having the schedule. Defendant mother will notify plaintiff father of the child's doctor's appointments on app close parties shall continue to use APCLOS for all communication. Child shall be enrolled in the defendant mother's school district. Again, parties shall use the front of the court holiday schedule. Both parties shall carry medical insurance if available at a reasonable cost. And my child will be enrolled on the defendant mother's sentence is interrupted. The tax exemption, I should say exemption issue is reserved. Let's see where we address child support. We refer the issue of child support to the front of the court for a recommendation, Ms. Patrick.
That request was not made by either party, Your Honor.
Okay. Any discussion, Mr. Edway, did you file a motion to modify parent child support?
Your Honor, I'm having trouble hearing you.
Okay. Did you file a motion to modify child support?
Yes.
Why was that not discussed during your conference with Ms. Patrick?
I don't know.
Okay, I'll put you back in the breakout room. Let's address both issues that are before the court this afternoon. Got to bring that to our attention, Mr. Adre.
Your Honor, would it be possible if I just refer to the front of the court? We're going to need a recommendation on the parenting time, and I can refer the child support to the front of the court.
All right, is that agreeable, Mr. Adre?
That's fine with me, Your Honor.
All right, we'll just check the box on this form recommendation that the issue of child support shall be referred to the front of the court for investigation and recommendation. Each party will have 21 days in which to object to any recommendation before it comes in order of the court. However, let's set an effective date. The effective date should be June 1st, 2024. When do you file your motion?
That's every weekend.
Hang on.
Go ahead, Mr. Adre.
I don't understand what we're objecting to or what. I thought we had a pretrial and we were going to set this for trial. I was unaware if there's a parenting recommendation by by Mary Patrice. I'm unaware of what it was.
Okay, I'm gonna have you talk with Ms. Patrick. I mean, we've got a major disconnect here. This is a post order matter. It's just a motion. Ms. Spencer has filed the motion to modify parenting time. You filed the motion for to modify child support.
Right.
So we have those two issues before the court. So I wanted to, first of all, if you're saying, nope, I don't agree to anything, let's have an evidentiary hearing, then we can address that. So let's, first of all, I'm going to have you put you back in the breakout room to talk with Ms. Patrick and Ms. Spencer.
Okay.
So we're on the same page.
That's fine.